Hello everyone and welcome to the 1-800-RESPECT webinar series. Today's topic is family violence and immigration law. 1-800-RESPECT is pleased to welcome Amy Farram. Amy is currently working in the migration team at Victoria Legal Aid's Civil Justice section on a project which looks at the provision of family violence migration assistance in Victoria. As a senior member of migration team, she has previously assisted visa applicants to litigate cases through the courts and worked on general migration matters, including the promotion, awareness and uptake of family violence migration cases within Victoria Legal Aid. This webinar is live and interactive. You are encouraged to participate by posing questions to the presenter. Your questions can be typed into the chat box, which is located at the bottom left-hand side of your screen. Responses to your questions will be answered at the end of the presentation. I'd now like to pass you over to Amy to begin today's webinar.
Thank you, Michelle, for the introduction and everyone for having me here today. I'd just like to reiterate that the information that you see on the bottom of this first slide, that the information is general in nature and not specific, and obviously people with immigration law issues should seek professional migration legal advice. Today we're going to look at family violence and the intersection between that and migration law. Having trouble clicking over there. Okay. Australia's migration legislation enables some temporary visa holders who experience family violence to regulate their status and obtain permanent residency independent from their former spouses. These provisions were enacted to protect visa holders in recognition of the fact that without them, people may feel forced to remain in violent relationships. Unfortunately, these provisions are not accessible to everyone who has a vulnerable immigration status and experiences family violence. I'll use the term family violence throughout this session. It's a term used by immigration and in this context mostly but not always refers to violence between domestic partners. Forgive me, I'll also use the term victim as it's a term immigration uses, though I'll endeavour where possible to refer to family violence survivors. We will look at who can access the provisions, what evidence applicants need to provide in order to satisfy them, and briefly touch on how the department processes those cases so that you might have an understanding of any clients that you're working with and how they're going, what they need to go through. We'll also look at what options might be available for people who either fail to satisfy the provisions or can't access them to begin with. We've just got a poll question next to give us a sense of how frequently you encounter this in your work. The question being, great, oh, have you worked with survivors of domestic violence who have had a vulnerable or uncertain visa status? Those results look like they're settling at about three quarters saying yes, no, and just a small percentage who aren't sure. That is helpful information to know, and I'm glad that you're aware of what immigration issues are faced by clients you work with. I'm also not surprised that people aren't sure because often clients themselves aren't sure. So it can be a bit unclear, but it's always helpful to know in order to make sure that the person who's experienced family violence gets the best referral. Visa vulnerability is sometimes used as a threat to control partners, and people in this situation need to be encouraged and supported in accessing good and independent advice about their migration status and what options they have independent of their abusive partner or whoever else might be abusing them. And that usually means not from the person who assisted them to apply for their initial visa. Oh, I just skipped ahead. Family violence is defined under immigration law and was recently brought in line with family violence as it's defined under other legal areas such as family law. In this case it means conduct, actual or threatened, which causes the alleged victim to reasonably fear for or to be reasonably apprehensive about his or her own well-being. The conduct needs to be directed towards the alleged victim, a member of their family or a member of the perpetrator's family, or towards their property or the property of a member of their family or the perpetrator's family. The conduct also needs to be, in order for it to be relevant family violence for immigration purposes, conduct needs to be by the sponsor or main applicant. They're the person who needs to be the alleged perpetrator. Sometimes abuse can come from others, in-laws, but if they're not agents for the spouse or the main applicant, then it can be difficult to argue that relevant family violence has occurred for these provisions. Now, when it comes to family violence provisions, what are we talking about? They are provisions that are available under some visa to some that are considered in response to some visa applications. I've got the list up there of the ones that they're mostly dealt with in regards to, and those are the partner visa applications. Family violence provisions can be found in relation to a couple of other visa applications, but it's quite rare, I think, for them to be encountered in those other areas. I just want to briefly, before we go into those partner visa applications, talk to you about just some general terminology that you may or may not be familiar with that would help you potentially to understand what a client might be telling you about the immigration situation. A permanent visa is, as you would expect it to be, permanent, and the person who holds that independently of whoever might have initially sponsored them to Australia. Some people I meet have a permanent spouse visa and fear that that visa is still dependent on their partner and they have to remain in that relationship, and that is not the case. A temporary visa allows someone to come here or to remain in Australia for a short period of time and for a specific purpose, to study, to work, to be in a relationship. Someone who experiences family violence and has a temporary visa may feel particularly vulnerable with respect to their migration status, where they are in Australia as a dependent of a primary visa holder or they're sponsored here by their partner. And it's certain of those visas that can access the family violence provisions. A substantive visa could be temporary or permanent, and if someone does not hold a substantive visa because it was expired or cancelled, or perhaps in limited circumstances they never held one, they'll be on a bridging visa or maybe without a visa at all, and they will be at risk of detention. A bridging visa is a temporary visa. It can be as short as a few days or a few months, and it permits the holder to remain in Australia for a limited and specific purpose, often while a consideration of an application might be ongoing, or they might be making arrangements to depart. So the visa subclasses that relate to partner visas are the ones listed there, and they are both the temporary and the permanent classes that I have listed. In order to access the provisions, a person must have an outstanding application. So when someone applies for a partner visa, they apply for both a temporary and a permanent at the same time. They're usually granted the temporary, and then the permanent is considered either at the time the relationship ends, if family violence has been a factor, or 2 years after the granting of the temporary visa. Holders of prospective marriage visas, which are also called fiancé visas, can also access the provisions if they lodge a spouse application. So that would be the onshore temporary and permanent spouse visas, which is the 820 and the 801. It doesn't matter that the relationship may have ended prior to them lodging the spouse application if, when they arrived in Australia, after arriving they married their sponsor. Fiancé visa allows someone to come to Australia temporarily for the purpose of marriage, which needs to occur within 9 months. Unfortunately, if the relationship breaks down before marriage, the applicant cannot access the family violence provisions should family violence have been a feature in the breakdown. As I mentioned, there's a small number of other visa categories. These are there's a child dependent applicant, distinguished policies, talents, visas, and a number of former visa subclasses which you can no longer apply, but people may have an outstanding application. It's important, sorry, I'm just going to go back before we get to that, to know and to be aware of the fact that temporary visa holders are usually required to keep the department updated with changes to their personal information, including their address and their relationship status. If these things change as a result of relationship breakdown, they should get advice about their migration status as soon as possible from a qualified person and notify the department of their new details. Some people who experience family violence disappear into the community due to being found by the perpetrator or fear around their immigration status. If the department does not know what happened to them or only knows what the abusive partner tells them, then they're likely to refuse a partner application if one is out. And the applicant will never get the chance to provide the family violence evidence. If they don't know about the decision, they'll also lose the chance to appeal the decision to the MRT, where they can also provide the evidence if they know about their right to appeal. If they later emerge from hiding, they won't be able to access the family violence provisions, and they'll find themselves in a really difficult migration position, possibly with no option to remain in Australia should they wish to do that, regardless of whether they experience family violence. So people who can access the provisions need to provide evidence to show that they have experienced family violence where that is the case. That can be either judicially determined evidence or non-judicially determined evidence, which some of you may be familiar with. Judicially determined evidence is an injunction under the Family Law Act, a court order, or a conviction finding of guilt. The most common judicially determined evidence I have come across is the court order and more particularly a final intervention order. A common question is, does it still count as evidence where those orders have been finalised with consent without admission? And the answer is yes, it's still judicially determined. You might understand this as nationwide. Intervention order is particular to Victoria. I understand in other states they may be called apprehended violence orders or protection orders. Non-judicially determined evidence may be provided alternatively or additionally to judicially determined evidence. Please note when I'm talking about non-judicially determined evidence, I'm going to explain the current requirements, which have existed since November 2012, as these are the ones that applicants need to satisfy in the vast majority of cases that you may come across now. You should, though, however, be aware that the provisions generally and the requirements for this type of evidence in particular have changed a number of times over the years, and occasionally there may be a long outstanding case where the first claim of family violence occurred several years ago, and in those situations the type of evidence that you may need to provide will be different. Hopefully whoever you may be working with has good representation. They can give you advice about those types of things to make sure that what is needed gets provided. So non-judicially determined evidence can be a joint undertaking to a court by the perpetrator. More commonly, it's a statutory declaration from the alleged victim or a person on their behalf, setting out all of their experiences, and at least two pieces of evidence from the list of evidence specified by the Minister, no more than one of each type. For those of you who have been doing this work for a long time, you'll be aware that this is the evidence that was previously provided by what was called competent persons. I just have another poll question for you, and that is whether, come up with, have you provided evidence for non-judicially determined claim of family violence before? Okay, I can see some of you have, which is great. Some of you haven't. That might be a reflection of the type of work you're doing or the cases you're encountering, but hopefully the information today will help you if you need to do this in the future. There's a second question which is about to come up. And that is, does your organisation have policies and procedures in place to support the collection and provision of evidence for migration purposes? And those results is largely what I expected. That's good that some do. And I think this work is not done so frequently that I would expect many places to have policies in place, but it's perhaps something worth considering or asking about if you're not sure. So great, thank you. I'm just going to take you through the types of non-judicially determined evidence that can be used. So this is the two additional pieces on top of the applicant's statutory declaration. There is a document that's attached to the webinar that you can access, I think, at the end, which sets out all of these and provides a bit more detail, including some of the information I'm about to go through as we go through these. So, as you can read, the information can include a medical report, hospital report, discharge report, a report, record of assault, witness statement or statutory declaration from a police officer, or a witness statement made in the course of the police's investigation that's by someone other than the alleged victim, a report or statutory declaration made by an officer of a child welfare or protection authority, a letter or assessment report from a Women's Refuge or Family Domestic Violence Crisis Centre on letterhead, a statutory declaration by a member or eligible member of the Australian Association of Social Workers, a statutory declaration by a registered psychologist, a statutory declaration by the family consultant or family relationship counsellor through family relationship centres, and a statutory declaration or letter on school letterhead by a school counsellor or principal. Now, you'll notice a few things there are italicised or underlined, and it's very important that the format used to provide the evidence is correct. So if you're asked to provide a statutory declaration, don't provide a letter. You need to provide a statutory declaration, otherwise it won't count. Obviously, if you can do a stat dec or a letter, it's up to you, but just be very careful about what form you use. Also be very careful about who can provide the letter. So it's the counsellor or the principal, it's not the student's teacher. In addition to being careful about who provides the evidence and in what form they provide that evidence, each of these different categories of documents are required to do different things. Just to take you back, for example, to the medical report, that must identify the alleged victim and detail the physical injuries or treatment for mental health that is consistent with claimed family violence. And it's very important that it does both of those things. In relation to the child welfare officers, they need to identify the alleged perpetrator. You'll notice it's perpetrator rather than victim, and details fear for the dependent child's safety due to family violence within the household. In relation to the report from the refuge, it must state that the alleged victim has made a claim of family violence, state whether, in their opinion, the victim was subjected to family violence, details any evidence relied on informing that opinion, and also identifies the alleged perpetrator. And each and every one of those things is really important in making sure that the evidence qualifies as a non-judicially determined piece of evidence. So just make sure that you're careful in providing all the necessary information. At best, you'll have a lawyer or an agent hassling you to fix it up if you haven't covered off on everything, and at worst, it won't be regarded as meeting the requirements for the application, and it may be refused as a result or referred to an independent expert, which we'll get to in a moment. So that's that's the evidence that the person will need to provide. It's also the minimum, so more is better, but we can talk about that in a little bit of time. I've set this up as you can see it because family violence now, was not always the case, but now can be made for the first time claim of family violence at either the department or at the tribunal stage. And the steps set out below are a very sort of rough summary of the steps that the decision makers go. And I'll just take you through these as if the claim of family violence was made at the departmental stage, because it's probably the most common way that a matter will arise. So at the department, the relationship ends, they've experienced family violence. They tell the department that they are no longer living where they were, these are their new details, and that they have been a victim of family violence. The department will then stop communicating with the sponsor about the application and will ask the applicant to provide more information. If the applicant needs more time to gather non-judicial evidence or there are upcoming relevant court dates, the department is usually quite good at allowing extensions of time, but it's really important that the applicant or their caseworker or their lawyer stays in touch with the department to keep them up to date about those things. Before the department, even if the department's made aware of family violence being an issue, before the case officer will go on to consider whether or not they believe the applicant experienced it, they're first going to consider whether or not the relationship was genuine. And if they decide that it wasn't genuine, then even if there's very strong proof of family violence, they won't be granted the visa. This issue of genuineness can be an issue that more commonly comes up where an applicant comes to Australia, for example, on a prospective marriage visa. They marry, but the relationship breaks down very quickly after that. If genuine relationship looks like it's going to be an issue for an applicant, it's even more important that they get advice and assistance and ideally representation in providing more information to the department. Of course, you might also be working with someone where the relationship wasn't genuine. It might be a forced marriage situation or some other type. And in those cases, the person who's been through that experience, if they need it, should be referred for more general migration advice about this type of application if they have one that's outstanding, or whether there's another type of option that they can explore. On the issue of genuineness, I just wanted to mention this because it can be it seems to be increasingly a focus of immigration to assess cases against this test. Where family violence has occurred, they'll look really, they have to consider it anyway, but they seem to be looking particularly closely at it. And a genuine relationship can be really difficult for a survivor of family violence to provide in situations where they've fled the family home, often with very little, and have been ostracised from people who knew them or were perhaps not well connected to begin with. So if you're working with someone who's experiencing family violence but is not yet ready to leave the relationship, it might assist them in the future if they're reminded to at least take steps to keep things like photos, gifts, cards, bills and joint names, anything that shows a life together and evidence of the relationship safe, so that after they leave the family home they still have that evidence and can provide it to immigration. If it can also assist a client just to think a bit outside the square about what evidence might be available to them. For example, if you're a medical professional like a GP who sees a couple together over the course of time and it later emerges that the woman has experienced family violence, the survivor's medical files noting that the couple attended together can be evidence that the relationship was genuine. So if if the relationship is regarded to be genuine, the decision maker will go on to consider whether the applicant experienced relevant family violence in the course of that relationship. And this is where the evidence, judicially determined and non-judicially determined, come in. If there is judicially determined evidence, the intervention order or conviction, apologies, it is binding on the decision maker. They have to accept that there's family violence, relevant family violence occurred, and to proceed to finalise the application on the basis that family violence has been established. If not, that judicially determined evidence isn't available, the applicant will need to have provided the non-judicially determined evidence. And those requirements I mentioned before, the two pieces in addition to the statement, they're a minimum. But more can assist the decision maker that they have enough to find positively that family violence has occurred, and do not have to refer the matter to the independent expert. So photographs of injuries, additional letters from community and family members, though given less weight than from professionals, can assist. So if you can help the survivor to capture or keep safe any evidence, it can really help them. If the decision maker is satisfied that family violence has occurred based on the evidence that they receive, and they meet the remaining criteria, they will grant the visa. And if they can't make a finding either way, they will refer the matter to an independent expert who will determine whether, in their opinion, the applicant suffered family violence. These experts previously worked out of Centrelink, but I know in Victoria that's now changed and it's a private firm, and I expect it's maybe similar elsewhere. A recent development that's troubling representatives is that we're now unable to attend these interviews, which pose a barrier to us being able to argue about any potential breaches of natural justice and procedural fairness. If the independent expert finds, after interviewing the person, which is what they normally do, sometimes they'll give them a chance to comment on information after the interview as well, but if after that process find that the person hasn't experienced family violence, the department is bound by that decision and will refuse the application. The survivor can then appeal the decision to the MRT, and then they'll then go through those steps again. They'll consider the genuineness. They'll ask themselves whether they are satisfied as to whether family violence occurred, and if not, the tribunal refers again to the independent expert. And as I mentioned before, a person can make family violence claims for the first time at the tribunal. So it might be that someone's application is just refused by the department just because it's non-genuine or just because they don't hear from them, and the person, for whatever reason, didn't provide them with information about family violence, and they can still do that at the tribunal stage, but it can be more difficult to be successful the later the person makes the claims, in part because where you're relying on non-judicial evidence, it can be harder to collect that. When you're preparing non-judicially determined evidence, there are a few things that can be important to recall, to remember, and that is to be thorough when recounting incidents. You don't have to go overboard, but detail is important, and it can help decision makers in making their decisions. And be detailed both in relation to incidents, but also what is informing your opinion and your statement. What are you basing that on? Be clear in what you are stating. If you're required to state your opinion, and your opinion is that she experienced relevant family violence, say that to avoid any doubt. For example, in my opinion, X has experienced family violence which has caused her to reasonably fear for her safety and well-being. Borrow the language of the regulation just to put it beyond any doubt that that is your opinion. Most importantly, be careful. Non-judicially determined claims of family violence often turn on the credibility of the person who experiences family violence. Capturing precise details, what, how, when, may not be your core business. You might be more focused on their immediate safety, housing, health, but it can be important that the notes you make at the time, and which might inform a later statement or a letter, are accurate, or that you seek clarification if necessary. At the time they're not, but just check afterwards. And also, of course, be aware if you're working often with people who speak English as a second language or no English at all, in language misunderstandings can be really significant. Interpreters might leave things out or misinterpret things. People who are highly distressed might not say everything, or it might not be clear what they're trying to convey. Inconsistencies between your reports and what the person who has experienced family violence says happened can lead to the person not being believed and having an application refused. The victim will hopefully have a lawyer or agent assisting them with their case, and they can give you guidance both on what your report needs to cover to satisfy legal requirements. They'll also likely spend a number of hours with the client helping them prepare their statutory declaration, setting out their experiences, and this might be available to you. Just be particularly careful about stating when incidents occur. It's good to include that information, but some people in reports might talk about when they think a relationship ended, and it might not always be entirely accurate, or it might create the impression that the violence occurred after the relationship ended. In order to be relevant family violence, the violence needs to have occurred during the course of the relationship. It's not necessary to state in evidence when you think a relationship ended, and it might be best avoided. So just on the point of when the violence needs to have occurred, relevant violence is violence that occurred in the course of the relationship. So even if someone is subjected to terrible violence and can prove that, they won't meet the requirements unless the decision maker is satisfied that the violence occurred during the relationship. Your focus might be on helping the person after the end of the relationship, or after violence occurs at that stage, because it might be most pressing for their safety, or it might be the most dramatic. But if incidences of violence occurred during the course of the relationship, it's really important that that information is not skimmed over or left out because something more dramatic happened right at the end. And just touching on the last one, people who have gone through family violence they obviously have a lot of things to deal with, housing and personal safety not being least important, but it's really important that they don't try and push immigration problems to the periphery. I've assisted some women who experienced terrible violence but didn't seek help at the time, or didn't at the time disclose the true nature of their experiences to the people who helped them, and it put them in a very difficult position when it came to trying to find evidence or gather the evidence. The department will give more weight to counsellors' reports where the person has seen them over a period of time and they have a detailed knowledge of the individual and the relationship, than to a counsellor who meets with the survivor once or twice months after the fact. But whether strong contemporaneous evidence is available largely depends on the survivor being supported and on the referral she gets. If someone sees a GP with odd injuries or a subdued presentation in the company of their spouse, but the GP doesn't arrange to later see that person alone in order to ask more probing questions, they may never get the referral to a counsellor or psychologist that they need. It's likely the doctor's notes will also fail to record important information that the survivor may have otherwise told them had they felt in a position to be honest with their doctor, and these records also may therefore be of little assistance to the survivor. So accurate, detailed records can be important. If you have an application outstanding for a partner visa and you've experienced family violence, but you also have children, you can obtain permanent residency on the basis of those children, where you need to show evidence of the children and provide evidence also of what custody and care arrangements are in place for them. For example, statutory declarations from yourself and your partner, which may be difficult if the relationship's broken down in the context of family violence, or a child maintenance order or another order regarding custody and access. For people who cannot access at all the family violence provisions, they're on student visas or other skilled visas. If they have children, the situation is tricky. Even where that child might be an Australian citizen, legal advice is essential. Where a child is also a temporary visa holder, the department may exercise discretion to enable the vulnerable parent to remain in Australia while the other parent is here by not cancelling a substantive visa or through a bridging visa, but it won't be a permanent solution, and it will and there's no substantive alternative visa that directly covers this scenario, so there's a lot of uncertainty for the family violence survivor. They could consider whether there's any other visa they can apply for in their own right. Could they meet the requirements for a student visa or a skilled visa, for example? But it's not common. I expect that they could, but they should always get advice about that. Another option that people who have experienced family violence might consider is whether or not they have protection claims. Those protection claims might be related to family violence or not. So where they're related to family violence, the prospects of success will depend on what their home country is and whether there would remain a threat to them there. So they will have to satisfy the decision maker that, among other things, there's a risk of serious harm. The decision maker would be considering, is there an ongoing risk of harm? How real is that risk if the perpetrator remains in Australia and they go back to their home country? Questions like, will the family continue to target the applicant in the home country might be relevant. And most significantly is, what will the state do to protect them? And will the state fail to protect them on account of the fact that they're a member of a particular social group? So, for example, a family violence survivor from the UK is going to be unlikely to be successful applicant for protection visa, but where she fears ongoing harm in her home country and she's from Pakistan or Sri Lanka or Papua New Guinea, the chances of lodging a successful protection application are significantly higher, and I know in those countries people have successfully argued that they will be at ongoing risk of persecution in their home country. Or their fears may be unrelated to what happened in Australia. For example, a single woman returning to Afghanistan may make the case that she's at risk from religious, political or gender violence from extreme members of society generally, or she might have any other number of risk factors that you might not be aware of. Maybe they're politically active or a member of minority religion. So it's always important for them to get advice about those types of options. Ultimately, it might be that a case ends up with the minister. Ministerial requests are requests to the Immigration Minister, presently Scott Morrison, asking him to intervene to provide a better outcome than the one the person has. You cannot ask the Minister to do this unless you've been through the Department and the Tribunal. It's very difficult to obtain a positive outcome, and policy providers will only do that in very unique circumstances. They'll consider things like impacts on Australian children, health and well-being of Australian family members and the applicant themselves. There was a very recent story in the media about Kerry Bailey, a victim of horrendous abuse in Canada, who was granted a visa to remain in Australia through ministerial intervention. It appears in recognition of the fact that to return her to Canada would cause her further and irreparable harm. So that's an interesting and somewhat on-point example of how ministerial requests work in situations where people have experienced harm. Some New Zealanders you may work with, and they're in sometimes a tricky situation where they can't obtain permanent residency. Generally, New Zealanders can come to Australia on what's called a special category visa, the 444. And if they're New Zealand citizens, they hold that in their own right, and they can continue to stay in Australia so long as they meet health and character requirements. Some other people are in Australia as family members of New Zealand citizens. And if their relationship breaks down because of family violence, they can't access the family violence provisions, but they can continue to stay in Australia on that family of a New Zealand citizen visa, irrespective of the breakdown of that relationship, as long as, excuse me, as long as they don't become, apologies, a member of a family member of a new person. If they did become a family member of a new person, or prior to doing that, they should obviously seek advice about what other immigration options that might present them. As with all of these cases, they can be quite complicated, and they should get good advice. Some people that you may encounter may appear to have been trafficked into Australia. Australia is a destination country. The majority of people trafficked into Australia come from Asia, particularly Thailand, Korea and Malaysia. Australia has a support for trafficked people program, which provides practical daily life living support, but also can assist people to access migration solutions. Just very quickly, bridging visas can be eligible, can be granted to suspected victims of trafficking or slavery who don't hold a valid visa, and enables them to stay in Australia for 45 days. They don't have to assist the Australian Federal Police in order to get that visa, and whether they get a further one is determined on a case-by-case basis. The criminal justice stay visas are granted at the request of the Australian Federal Police. You can't apply for that visa as such, so whether you get it will depend on what the Australian Federal Police regard as your assistance and your circumstances. They might not agree that you have been a victim of trafficking. Sometimes their determinations differ from ours. And after the criminal justice stay visa, someone might be granted the permanent visa. And this is in a situation where the suspected victim has made a contribution to an investigation or prosecution and would be in danger if returned to their home country. Very few of these visas had been granted. Just for example, in three of the permanent visas were granted in the first 6 months of this year, 4 of the criminal justice stay ones. The previous 6 months, only 2 of the permanent visas were granted. And that is out of a total of about 69 people who were assisted through the support program. If you think you have a client who may have been trafficked, it could be really important to refer them through to Red Cross, and they run the support program. And also, importantly, please note that the support program is open to both people who have been trafficked and also people who have experienced forced marriage. In order to actually get direct assistance through the program, they need to be referred by the Australian Federal Police, but their first port of call can be the Red Cross, and they can have a chat with them about the program and the process and learn more about it and decide on whether what they want to do in terms of approaching the Australian Federal Police, who I understand are also in this area very well trained and approachable. I don't have it up there, but the website for Red Cross, the email address, if you have a client in these circumstances and you want that initial first point of contact with Red Cross, is national_STPP@redcross.org.au. I think I've got a little bit over time, but hopefully we'll have enough time for a few questions.
Thank you, Amy, for your presentation. Now, we do have time for just one or two questions. Just before we jump over to the questions, I'd just like to let everybody online know that there is, if you'd like, a certificate of attendance for participating in the webinar today. You can download the certificate using the link now in the chat box, and there is also a document on non-judicially determined evidence which you might find useful. So we've got time for just a few quick questions here. So the first question is, how do you generally receive a referral, and what information is it important for the referring agency to communicate?
It's a little bit unclear to me where the question is about referrals to lawyers. I'll assume that that's the case. How do immigration lawyers get referrals and what's important to them? The client's details, their happiness to communicate with you about their case. Usually it's important for us to communicate mostly directly with them, but if they are happy for a third party to provide us with information or to be a point of contact, that's great. And initially just the bare bone details of what you understand the client's situation to be in, and the lawyer will then take it from there and will use that information to try and untangle the immigration situation and figure out what's needed and where the best evidence can be obtained from. So hopefully that's answered the question.
That's great. Thanks, Amy. Now, unfortunately, we have gone a little bit over time, so that is all the time that we've got for today. Now, just as a reminder, that certificate of attendance for participating in the webinar, the link is in the chat box. You can download that from the chat box in the bottom left-hand side of your screen. Now, on behalf of the entire 1-800-RESPECT team, thank you for attending this webinar, and we hope that you've found it valuable. Please stay online now to take our quick survey. Thank you.